Hello. Hello, and welcome to this incredible day where we get to be in your presence and in presence with one another for a very big celebration. Alongside our esteemed partners, A Better Balance, ACLU, National WIC Association, Center for WorkLife Law, and MomsRising, the United States Breastfeeding Committee is thrilled that this day has arrived. Next slide. We all got a very happy New Year's present in the form of the Providing Urgent Maternal Protections Pump Act for nursing mothers was signed into law. So now nearly 9 million more women of childbearing age have a right to break time and a private space to pump breast milk during the workday. All workers have a private right of action if their employer does not comply. We've created a mandate and we've created the conditions where that mandate can be enforced. Next slide. This is a big win for babies, for parents, for public health, and for every advocate who's on this call or who has ever played a role in bringing this moment about. You know, at this time where we are allowing and condoning routine separation of parents and children during the workday without a national paid leave law yet. The Pump Act addresses one of the most challenging barriers to breastfeeding, which is having accommodations when returning to work. And it took everyone to make this happen in this very challenging political climate. And we just saw policymakers who were able and capable did the right thing, and they put families first. And that's largely because families made it clear that it's time. So because of your advocacy, this has all come to pass. Supporters drove thousands of calls into Congress, hundreds of thousands petitions, hundreds signed petitions that allowed this to go forward. And it was supported by hundreds of organizations. So much power, so much power. Next slide. So we made history together, right? This is the first standalone lactation bill to receive a recorded vote in both the House and the Senate. There were 276 yes votes in the House as a standalone House bill. And after unanimous bipartisan support, with lots of help from the Senate Help Committee, there were 92 yes votes in the Senate when this passed in December. Next slide, please. So we want to thank all of our champions. So we know that this came about not only because of the big push at the end, but because of everything that happened for decades preceding it. We know that grassroots citizens and community organizations brought the vision and were in it for the long haul. There were state legislative champions who helped to pass over 30 laws across the nation. And when you have that kind of spread and reach, it makes it very clear that a national law needs to happen. So coalitions and the Workplace Support Constellation work together along with the Pump Strategy Group, that's all part of co-hosting today's webinar, to bring this to fruition. And we must thank our Pump Act champions, Senator Merkley, Senator Murkowski, Representative Herrera Butler, and Representative Maloney. And in particular, we need to thank Senator Jeff Merkley, who was in this picture from 2007 when Oregon's law passed and was here all the way to the finish line to make sure that this happened for our nation. Next slide, please. And so thanks to thousands, millions are now served. So thank you very much for being here, everything you did to get us here, and onward we go. So I'd like to pass it now to Sarah Braffman from A Better Balance.
Thank you so much, Amelia. And like Amelia said, I'm Sarah Braffman. I'm National Policy Director at A Better Balance, and it is incredibly exciting to be here with you all today. And as part of the next piece of what we want to talk about and share with you all is the story of how this bill became a law, because it is truly a journey, and it was really a long and bumpy and at times painful, but often joyous path to get here. So we're going to start with the next slide, talking first about House passage. And really, we're going to talk about the last 2 years of the campaign. Like Amelia said, this campaign was over 10 years long, but the last 2 years have been the most eventful, and of course, what led us to passage today. So in the House specifically, first there was, and this is a little bit unique, in March of 2021, before the bill was even reintroduced, the House Education and Labor Committee held a hearing on the bill, and it was an opportunity to really talk about and present why the Pump Act was so necessary. A Better Balance co-president Dina Bax testified. Every organization here leading this webinar and leading the coalition submitted very extensive testimony to make the case for why the bill was so critical to support the nearly 9 million people that didn't have rights and the tens of millions that didn't have real remedies for violations of the law. In May of 2021, the Pump Act was reintroduced. And then in September of 2021, this was a really critical juncture for the bill. For a good amount of time, we had been talking with the US Chamber of Commerce to try to garner their support for the bill, which is, as many folks on this call know, very important to get their support for a bipartisan bill, especially. We wanted to make very clear to everyone involved that this was a bill that would be beneficial both for workers and for business, that closing the gap in the law would provide really necessary clarity for business that they didn't have up until this point. And that proved to be very fruitful. And those negotiations led to a compromise bill that still kept the core pieces of the legislation intact and strong and beneficial to workers and employers alike. And that in turn led to October of 2021, which saw the Pump Act pass on the House floor. Like Amelia said, we got a standalone vote where we garnered 276, I should say, yes votes, including 59 Republican members, which is really rare to see when it comes to a piece of labor legislation. Next slide. After the House, or I should say simultaneous to the House introducing the bill, the Senate had introduced the bill and held a hearing as well, and unanimously passed through committee the Pump Act, meaning that both Democrat and Republican members unanimously supported the Pump Act. Senator Burr from North Carolina spoke about the support for the bill, and it was a really great showing. Fast forward after that committee hearing, and that's where things became a little bit bumpy. No pun intended, because when we say they got bumpy, it was primarily owing to the airline industry opposing the bill. And they made many claims about why they shouldn't have to provide break time and space. And we, along with our partners at the airline unions, the pilot unions, came together to make a very strong case that airlines can, of course, accommodate break time and space for flight attendants, for pilots. In fact, airlines in many cases are already doing that. Some already have policies in place. And so we fought extremely hard to make sure that flight attendants, that pilots would be engaged with our sponsors alongside the unions in very close negotiations for a very, very long time. And we'll talk about the outcome of that a little bit, but I think it's really important for folks to understand that these were years-long negotiations that we engaged in, and was a very hard fought battle to try and get them included, and as we'll talk about later, is one that will be ongoing. So the next slide takes us to June of 2022, where we had been pushing really hard, had come up with language that was really fair in terms of addressing some of the airline industry's concerns. And mind you, we'd already started doing that on the House side. In that version, there was already language. We had continued working with them. And it really came to a point where we needed to expose what was going on. And so Senator Merkley did something really interesting. Was he went to the Senate floor and he engaged in something called a live unanimous consent procedure, where if a senator goes to the floor and brings up a bill for a vote, if no one objects, if no senator objects, then the bill passes. But if even one senator comes down to object, then the bill doesn't pass. It doesn't mean that the bill can't pass later, but that attempt has failed. And it's really a way to snuff out opposition, that, you know, if members have opposing viewpoints, that it shouldn't just be behind closed doors, but people should be, you know, public and transparent about what their concerns are and why they don't necessarily want to support a bill that would help millions of lactating workers. And what happened there was that Senator Cynthia Lummis from Wyoming came down and voiced opposition, not only based on airline industry concerns, but voicing a new concern around the rail industry and safeguards for that industry, and opposition from them. And we'll talk a little bit more about Senator Lummis, but that was the first time she really engaged publicly with the bill, but not the last. And with that, I will turn it over to my colleague Tina Sherman from MomsRising to talk a little bit more about this journey.
Thank you, Sarah. Well, this is where more effort was put in, and all of you on this call stepped up and stepped in to help us all with this fight. You helped us gather more stories from parents and deliver storybooks to key members of Congress. And also, we started with making more calls. We had text-to-calls going out. More calls were placed to senators' offices. And we had some letters to the editors penned. You'll see one right here that was in the Star Tribune that was penned. Again, critical pressure that was being applied from all of you, from grass tops, from grassroots, from parents, from practitioners, applied to members of Congress to let them know exactly what was at stake for families and exactly what we needed, what families needed. Next slide, please. So we're going to talk now more about the second UC attempt. The second unanimous consent attempt. A bipartisan group of senators continued with negotiations on amendments for rail workers, motor coach operators, and flight crew. Railway negotiations were settled, but airline opposition continued. With only a few days left in session, left in the congressional session, literally at the end of the year last year, Senator Merkley made a final, desperate attempt to pass the Pump Act in the Senate via unanimous consent. This time, Senator Rand Paul objected, instead requesting a study on this necessity of the legislation. And we're going to cue this up where Senator Murkowski went to the Senate floor to talk about the importance of this legislation.
Requirements on businesses. I have been the lead Republican on the Pump Act now, working with Senator Merkley for a couple years working to get to this point. And it is so unfortunate that at this late date on the calendar, as we're looking to close out, that this measure, this important measure, important for mothers, important for babies, important for employers, but it's so unfortunate that it is being held at this moment. And it is.
Thank you, Cheryl. So the next clip Cheryl's going to pull up with us is Senator Rand Paul's objection to the unanimous consent for the Pump Act.
Even extended how long nursing mothers are covered by the law. Since all of these accommodations already exist at the federal and the state level, before we impose any new mandates on the whole country, we ought to study whether there is actually a need for more legislation in this area. I have an amendment to strike these new mandates and instead ask the Government Accountability Office to study this issue and report back within a year. I would ask my colleagues to agree to this amendment so we can.
And finally, Senator Merkley responds to the objection on the Senate floor.
This issue. This is now 8 years that this topic has been before us. It has not just been studied in some academic sense, it's been studied in real life. And we still have thousands and thousands of women who have great difficulty getting permission to pump breast milk when they return to work. Those who have been accommodated say it has made a big difference in their life, about their bonding with their child, about their health as well as the child's, which is a point that Senator Coburn made. We have this in place for 50 or 49 million American women. Why have we left 9 million out? And
Senator Merkley so beautifully getting to the point, 9 million working mothers were left out. So in our final shot, the Pump Act was not included in the omnibus spending package proposal, and we were all devastated again in those last few moments of negotiations at the end of the year. But Senator Merkley did not let this go. He proposed an amendment to the omnibus. Unfortunately, we did end up carving out flight crew and included negotiated language for railway workers and motor coach operators. But this meant that the amendment was headed to the floor and passed with 92 votes. Next slide, please. So the Pump Act was signed into law as a part of the omnibus spending package in December 29th of 2022. And now I'm going to hand it off to my colleague, Jessica Lee with the Center for WorkLife Law to talk exactly about what is in the new law.
Thanks, Tina. You certainly got my blood boiling there. Hi, everyone. I'm Jessica Lee. I'm Senior Staff Attorney at the Center for WorkLife Law, and I'll be joined in just a moment by my colleague, Liz Morris. Now, we know there has been some confusion around the House bill versus the Senate bill. As you just heard, there was a ton of back and forth. And so we want to give just a little overview of where we ended up. Right now, even if you do a Google search for the Pump Act, an old version of the law often comes up. So we're going to be trying to give you that overview of what you can expect and how you can educate folks in your community on the Pump Act and what it means. So first, you got a little taste of this, but just a refresher where we were before the Pump Act. Since the Affordable Care Act passed over 10 years ago, we've had that break time for nursing mothers provision. That law required employers to provide as needed break time for milk expression and a non-bathroom space, which needed to be free from view and intrusion. And they needed to provide it for at least 1 year following birth. As we've talked about, that law significantly improved the lives of lactating workers and their families. And studies have even shown that workers who had access to both break time and space under this law were over twice as likely to be breastfeeding exclusively at 6 months and continued to have higher rates of breastfeeding beyond 6 months. But there were those unintentional and important gaps. That's because the lactation break time and space law was put into a section of the law governing overtime. And as a general rule, only those employees who were eligible for overtime were eligible for federal lactation protections at work. Employees weren't covered, like teachers, registered nurses, lawyers like me, and others were confused about their rights. Employers were mixed up, and we were hearing about this from USBC members, public health workers, and many more folks on our helpline. So we decided to dig deeper into what's going on. We crunched the numbers with the help of the Economic Policy Institute and discovered that it actually was 9 million workers of childbearing age that had been left out of coverage of that federal law. And that equates to about 1 in 4 working women of childbearing age in this country. So that is a number with a massive impact on our workers and babies and our families and communities as a whole. In addition to crunching the numbers, we looked through every breastfeeding and workplace lawsuit brought over the last decade, and we found that all workers were hurt by the fact that this law was virtually unenforceable in court. The Department of Labor is able to respond to complaints, but there was no option to get meaningful justice in the courts. Even when nursing parents were treated poorly and the law was undoubtedly broken, like when an EMT was fired just for asking for lactation breaks, judges said that their hands were tied. So under the old law, people were left out, others got confused, and many employers wrote it off, thought they didn't need to take it seriously because they couldn't be held accountable in court. As a result, perhaps it wasn't surprising that studies also showed 60% of lactating workers didn't actually get the break time and space they needed under the old law. So this is where we were before the Pump Act. Now enter the Pump Act, hopefully changing this script. Liz, can you walk us through how the Pump Act addressed these points?
Yeah, thanks, Jess. That was an excellent job setting up why this law was so desperately needed. I'm Liz Morris. I'm the Deputy Director at the Center for WorkLife Law. The Pump Act did 3 really important things. The first is that Pump gave lactation rights to millions of workers. That coverage gap that we've been hearing about was almost entirely closed by the Pump Act. So teachers, nurses, farm workers, and many others are covered now. And we have now underlined there to make clear that these folks are already covered. This part of the law is in effect, and they have a right to break time and space. There are certain railway and motor coach workers who are going to have their rights in 3 years. So the industries have time to figure out how to comply. But it's a fairly narrow group of employees whose rights are going to be delayed till December 2025. So it's members of train crews who are involved in the movement of the locomotive, and also rail carrier employees who maintain the right of way. And for employees, it's those who are involved in the passenger bus, but that doesn't include public transportation, and it doesn't include school buses. So all other employees that I haven't just mentioned are covered, even in those industries, immediately. Also, for those that sort of narrow group of employees, their employers don't have to incur significant expenses to comply, like removing seats from train cars or from buses. There we go. So as was mentioned earlier, there is unfortunately one exclusion that is remaining even after the Pump Act, and that's airline crew members. Specifically, flight attendants and pilots are the only workers who are carved out of the FLSA's break time and space requirements, nonsensically and unjustly. And I say nonsensically because it is eminently possible to provide break time and space for flight attendants and for pilots. They can use curtains. There are wearable breast pumps, of course. Flight crew members already attend to their other biological needs, like using the restroom, and the same steps that are put in place there can be put in place to ensure that they're able to get break time and space. And in fact, many flight attendants and pilots already do receive break time and space. Alaska Airlines even has a policy on its books on how to do that. So it was unjust that these folks were excluded from the law. Essentially, the airline industry held the entire bill hostage if senators wouldn't give them a total carve out from all state and local lactation laws. So it was, it was a true injustice. These workers deserve to have the same treatment as everyone else. And we're going to continue fighting for them and share a bit more on how you can join us with that shortly. Okay, the second thing that PUMP did was it provided a meaningful right to sue. So starting on April 28th, 2023, employees can file a lawsuit in court against their employers for violations. And workers can sue for a lot of different types of damages, actually. The first is lost wages. So if somebody's forced out on unpaid leave, because they weren't given break time and space, or if they're fired for asking for break time and space, they can recover those lost wages. And actually, twice the amount of their lost wages is available to them in many cases. That's something called liquidated damages. Also, if they suffer other economic harms, they should be able to recover for that economic harm in court. Emotional distress damages are really important in the lactation context, where not receiving the break time and space that nursing parent needs could have devastating impacts on the breastfeeding relationship, on health. And so emotional distress damages are also available. Additionally, punitive damages in some cases may be available where the employer has sort of willfully, flagrantly violated the law. And then also attorney's fees and lawsuit costs can be recovered, which is really important, because that means that lower wage workers, folks who can't pay for a lawyer out of their own pocket, will have an easier time finding one, because if they prevail, they will be able to recover the attorney's fees and the lawsuit costs. To file a lawsuit, important to note that an employee must notify their employer if the space provided hasn't been adequate. Or is not adequate, and then allow the employer 10 days to correct that violation before a lawsuit can be filed in court. Now, that just pertains to the adequacy of the space. Employees are not required to notify their employers about other violations before they're allowed to file a lawsuit. So if somebody's fired just for asking for break time and space, or if they're not given breaks as needed, then they can just go directly to court if that's what they need to do. And then employees are not required to file a complaint with the Department of Labor before they file a lawsuit in court. The right to sue is a big deal. Shout out to my colleague Jessica Lee for putting this photo in the slide. I love it. It is shocking that it actually passed with this right to sue included. It's really easy. I think we can all agree to get behind the idea that teachers and nurses shouldn't have to stop breastfeeding when they return to work. But it's pretty miraculous that there was such widespread bipartisan support for a bill that holds businesses accountable for violations and does expose them to litigation when they violate the law. Honestly, I never in my wildest dreams would I have expected this to happen at the federal level. It's really incredible. We talked about how it needed to happen, but it's surprising. And being able to sue is critical for widespread compliance. The previous inability to sue meant that the law just didn't have teeth, and employers are far more likely to comply with a law when non-compliance can cost them. And that makes sense. So it's important from a justice perspective that individual parents whose rights have been violated will have an opportunity to go to court and seek justice and seek compensation for the harms that they've suffered. But from my perspective, at least, that's not even necessarily the most valuable part of the private right to sue. Rather, it's the work that it does to encourage widespread employer compliance with the law. There's actually social science research showing that I think 8 different lactation-related laws, the most effective kind of law at actually increasing breastfeeding rates is a break time and space law that has a strong enforcement mechanism. So this is huge. Now, it's true that many people whose rights have been violated aren't going to be able to file a lawsuit, for all sorts of reasons. One of which being they may not want to, because many people, after something, especially that can be traumatic in the lactation context that we're working in, want to move on with their lives. They don't want to get into a fight with their employer. Totally understandable. But the benefit is that so many people are going to benefit from the lawsuits that are filed, even by other individuals, because they're going to make employers more likely to comply with the law. Okay, and then, the final thing, I guess we can still read this. The final thing is that PUMP clarified existing wage and hour law. So before PUMP passed, it was already, the law was already true that employees must be paid federal minimum wage and overtime for all hours worked. And hours worked is basically, like a legal term that means time spent performing any work duties. So that was true before PUMP. And then PUMP clarified, was already true, but PUMP clarified that an employee is doing, if an employee is doing any work while pumping, then that time counts as hours worked when calculating minimum wage and overtime. So unfortunately, this doesn't mean that pumping breaks have to be paid under federal law. However, when I say that, it is also important to point out, and I know Jessica will talk about some of the state laws that provide protections, but it's always important to note that there are 3 states, Illinois, Georgia, and Minnesota, that provide paid pumping breaks. And there are other states where somebody has to be paid their agreed upon wages if they're working, if they're doing any work. There are states that have paid rest breaks. So this is all to say that even though this federal law does not provide a right to receive paid pumping breaks, there are situations in many states where somebody would be paid for their pumping break. And I'm gonna hand it back to Jessica Lee.
Thanks, Liz. Okay, so that's what's changed, but here's the big picture. So if you're working with employers or employees, this is a snapshot of the rights and obligations as they stand today compared with where we were before. First of all, you heard it, pretty much every worker is going to be covered except flight crew. Those certain transportation operators are on a 3-year delay. But we no longer have this funky overtime rule. It's now all workers except flight crew. If we look at the employers who are covered, that hasn't really changed. It's still employers of all sizes. Those with fewer than 50 employees may have an exemption in rare cases where it would cause an undue hardship. But as we learned through this process of working on the PUMP Act, the Department of Labor told us they haven't found a case where there has been a true undue hardship. So again, rare, rare, rare. This is not the rule. Employers, small employers are still covered. There's just that rare exception. How long? They're still covered for 1 year following birth. Some of you probably like me were very excited when the House bill talked about maybe giving 2 years. Unfortunately, that's not where we ended up, but we still have that 1 year following birth. And I'll talk about some gap fillers for this shortcoming in a minute. Break time still has to be provided to those employees as often as they need it. Lactation space requirements haven't changed between the old version of this law and now with pump. The space still needs to be a non-bathroom space, and it must be free from intrusion and view. And then when it comes to the enforcement, before the primary enforcement, that's the Federal Wage and Hour Division. But now we still have them. You can still file complaints with the Department of Labor's Wage and Hour Division, but you can also go to court and with meaningful remedies. So this is our snapshot, and this will be sent out and posted online. So if that's helpful to you, you can have access to it in the future. But as you can see, this still only addresses break time and space just for a year. But there are some additional laws that can also help folks who aren't as strongly protected by this. So let's talk about the overlap with these other protections that we already have. State protections are still in effect. Pump Act does not replace any state protections. So most people are protected by both state and federal law now, which is an excellent position to be in. So we view the Pump Act as a floor that no one should be able to fall below. Other laws, like state and local laws, can build on top of it. So for example, as Liz mentioned, we have those 3 states that require all pumping breaks be paid. That still stands in addition to these protections. Other states have the basic break time and space requirements, but they add protections about the lactation space. So for example, saying it has to be close to the employee's workspace, or there has to be access to running water. Again, both the federal law and that state law will apply. Whatever protection is the strongest in your circumstance is what you should roll with. Another important point to note is that state laws cover those workers, those few workers, unfortunately, who aren't currently covered by pump. So that includes, for the next few years, some of those transportation operators and airline crew. And in many states, those state laws are also going to bring coverage to those workers who are nursing a child over 1 year of age. So if you are looking at the federal law and you're saying, this is enough in my circumstance, please, please, please visit our website. We have more at that Pregnant at Work link on what's going on in your state. Look to the state laws to go that next step in many circumstances. And then one final note on this point is that there is another hugely important law on the horizon, and that's the Pregnant Workers Fairness Act. That was also passed in a last-minute bit of glory, and that law is going to be in effect in June, and it's going to require employers with at least 15 employees to make reasonable accommodations for lactation and other pregnancy-related conditions. So starting in June, you can use the Pregnant Workers Fairness Act to get an employee lactation break time and space beyond 1 year, or get other changes at work, like a shift in duties that might be helpful to make it possible to keep breastfeeding. Under this new law, employees are going to be able to ask for any changes they need to protect a pregnant or postpartum employee's health, so long as those would not cause an undue hardship on the employer. So this is going to be pretty transformative, and we're going to be back with more training specific to the Pregnant Workers Fairness Act. This could be a presentation in and of itself, but I hope that you all will keep this on your radar. Please know that this is coming. There is going to be an extra layer of protection starting in June. And if you want a sneak peek into what that's going to look like, there's another link here on your screen, more on PWFA from our partners at A Better Balance. Okay, need help understanding this? I know we've thrown a lot at you today, but more tools are coming soon. Center for WorkLife Law and A Better Balance are updating our guides for employees, talking to your boss about your pump. So look for that soon. It'll go out in the weekly wire, be shared widely. In the meanwhile, though, if you're listening to this and you can't stay for question and answers, or you have questions that we aren't able to address today, please don't hesitate to get in touch. We want to be a resource to you and the communities that you serve. Center for WorkLife Law has a helpline. Information's on the screen. A Better Balance does as well. And we support people in multiple languages. So please don't hesitate to give us a ring, and we can talk you through the rights that exist in your state or your circumstance. All right, I'm going to pass it on to Cheryl, who's going to talk us through what's next. Cheryl?
Thank you so much, Liz and Jessica. Really, really grateful and really happy to see tons of questions coming in. We will get to those. So please do keep your comments and your questions coming in so that we can be as helpful as possible. Before we move to that, we have just a couple of pieces. So we wanted to talk first about what's next. Can you move to that next slide, please? As you heard, there are some pieces that are still left to be done. So all of us here who are hosting this event today, and so many of the folks in this really incredible lactation field who have worked toward this big success, are very committed to making sure that this very sensible, very reasonable right to reasonable break time in a private space to pump is available for every single worker in the nation. So you will continue to see us working towards expanding coverage to include every worker so that these airline crew members are not left without the really simple basic supports that they need. Please do stay tuned. If you are not yet subscribed to the Weekly Wire newsletter, I'll pop the link into the chat in just a moment. Please do subscribe because you'll see news and updates and action alerts included in that newsletter. A really important thing that you discover when you're doing this policy work, of course, is that passing the law is only one step in this process, and that does not by any means mean that your work is finished. So we now have these rights on the books. We are so thrilled to see the Pump Act included in the U.S. Code, but our work is not yet finished. So we do need to continue to work all together as a field and make sure that we're really supporting implementation of these new protections. The U.S. Department of Labor, as you've heard, is the agency that's charged with enforcement of this legislation, just like they have been under the Break Time for Nursing Mothers Law. So we'll be continuing to work with and support this agency as they work to enforce and implement and really educate the public about what this means. And we'll be working to really make sure that it is interpreted with the full spirit of this legislation so that we're addressing any concerns, the questions that are coming up from businesses and workers. We also have a really important role to play around educating the public. So we know that after more than a decade with the Break Time for Nursing Mothers Law, we were still working to educate people that this existed. And we will continue to do that with the Pump Act. And it really will take all of us working together to make sure that every new parent is aware of their rights, that every business and organization understands what it means to really support their workers and what they need to do in order to be in compliance, and really providing the support that they need, the practical resources. There are resources out there. The Office on Women's Health hosts a really great resource that has examples from businesses all across the country. So we'll all be coming together to really do our part to spread the word about these resources moving forward. So please, we have this big victory. We are so thrilled, and we are not going away. We're going to continue doing what we have to do to make sure that every parent has what they need to be successful and to reach their own breastfeeding goals. We will switch gears for just a moment and move to the next slide, please, Jess. We just want to really thank you all for being on this journey. We know that we have asked a lot. We have asked frequently at every stage of this process. And so much of our success can really be credited to the field's just really commitment and dedication to bringing the right message from the right messenger to the right listener at every step along this journey. There are so many decision points and so many decision makers, and it took so many hundreds of organizations and thousands of individuals to move us through that process. And here on the screen, you can see what we call ourselves our Pumped Coalition, who have been stewarding this bill all along the process. You've heard from most of us today. If you're here, you probably are seeing a familiar face on the screen. Vanya Lavelle on the top left from ACLU, Jessica Lee from the Center for WorkLife Law to her right, Sarah Brofman from A Better Balance to their right, and then following along, Brian Dittmeyer from the National WIC Association. You can see me on the bottom left, Liz Morris from Center for WorkLife Law, Amelia Pasmai-Seeger from USBC, and Tina Sherman from MomsRising. We have been through a lot of ups and downs, as you have heard. We have really been able to lean on an incredible community of advocates. So thank you for keeping us inspired, picking us up off the floor when things were looking really dark, and soldiering on when we needed to. We are not going anywhere. We are all available. Please do reach out to us. If anything comes up, if you have questions, we really do remain committed to moving this forward, and just want to thank you all seriously for being on this journey with us. And with that, I actually am very, very happy to introduce someone who has given all they had and then some, which is Matthew Traylor from Senator Merkley's office. Matt has really fought to make this happen. Many late nights, many really difficult decisions, and long days. So really happy to welcome Matt here with us today.
Thank you, Cheryl. Appreciate the introduction, and yeah, it's wonderful to be here today. See all the friends that have worked so hard on this bill, this coalition. You know, this was a remarkable effort for everyone bringing their skill and their passion and their perspective to bring this to ultimately being successful, including the omnibus. I'm still kind of in shock that we pulled this off, but you know, I appreciate it, and I've been kind of reviewing it as we go through this presentation today. It's been really helpful and really inspiring to see, you know, what real change looks like. So thank you all so much. I don't really have much more to add other than what a wonderful day, what a wonderful team we have here. So thank you.
Thank you so much, Matt. You have been brilliant and have a lot of stamina that we really couldn't say enough about. Matt has really been the one for many years, really through its earliest stages of the Pump Act. It took us 6 congressional sessions to move this bill, and we got there. So thank you so much, Matt. And of course, to your boss, please do share just our deepest appreciation.
Yeah, sorry, he's on a flight right now. We tried